and welcome to BloombergQuint. You're watching the fine print. Lenders reeling under the pressure of recovering dues from insolvent companies have run into another wall. The National Company Law Appellate Tribunal has ruled that lenders cannot invoke guarantees given by promoters while the borrower is facing insolvency proceedings. Curiously, this ruling is contrary to the previous orders of the Appellate Tribunal. Shivani Saxena reports on the facts of the case and the implications of the ruling for lenders.
The State Bank of India was amongst the many lenders who initiated proceedings against guarantors to recover their dues. But the introduction of the Insolvency and Bankruptcy Code put a spoke in the wheels. In one such case, after the insolvency proceedings had started against the borrower, a company called Veson's Energy Systems Private Limited, the promoter and director of this company, V. Ramakrishnan, approached the NCLT to halt SBI's proceedings against him in his capacity of a personal guarantor. The Chennai NCLT bench ruled in his favor and held that on satisfying SBI's claim, the guarantor, in this case V. Ramakrishnan, would substitute SBI as a lender. As a result, this would create a fresh security interest on the company's property. This interest will be created during the moratorium period, which is the period between the initiation and termination of insolvency proceedings, where all other legal proceedings in relation to that company and its assets stand abated. The tribunal ruled that creation of a fresh security interest or encumbrance during the moratorium period would affect the liability of the borrower and therefore cannot be permitted.
I personally don't agree with that view, and that is why the law which is being framed under the IBC is pretty clear and pretty simple, that the assets of the corporate debtor should not be touched or should not be altered with. If you remember SICA, I think under Section 22 there was of SICA there was this restriction on invocation of guarantees or a stay on the assets of the debtor as well as the guarantors, and this was misused quite often, and that is why if you see the IRADA committee report as well, it was pretty clear that Section 22 should not be continued.
However, contrary to the recommendation of the IRADA committee, on appeal, the Appellate Tribunal concurred with the reasoning and the findings of the Chennai bench of the NCLT. It ruled that the moratorium period for an insolvent company would also extend to the properties of the personal guarantor.
So earlier the banks of course would continue to enforce the securities given to them because their primary focus was the recovery of the money owed to them. If the company goes through the CIRP process, naturally there would be an embargo upon enforcing the securities given by the company. So the banks and ARCs would prefer to go against the personal guarantors. Of course, sometimes there are other reasons, such as the company may not have assets while the personal guarantors do. Now, because of the NCLAT judgment, the banks and the ARCs would be prohibited from going against the security given by the personal guarantors also during the CIRP process. This cannot be said to prejudicially affect them per se, because if no resolution plan is reached at the end of the 180 plus 90 days, then in the liquidation stage, they could of course be free to go against the securities given both by the company as well as the personal guarantors. The maximum prejudice that could be said to be caused to them is that period of 6 to 9 months during which they cannot do either. The benefit, on the other hand, is that by throwing in the securities that the personal guarantor has given with the overall assets and securities that the company itself has given, a resolution plan can be made more holistic and can use those securities to, for example, secure any further debt being taken by the corporate debtor.
What makes the situation even more complicated is that this appellate tribunal order is contrary to its earlier rulings. In two cases, Phoenix ARC and Alpha and Omega Diagnostics, the appellate tribunal held that under the IBC, the moratorium period will only extend to the insolvent borrower and not the guarantors. So which view of the appellate tribunal will bind the future litigants, some of whom could be corporate and not personal guarantors?
In the past two instances, NCLAT categorically dealt with only the word "its," which is appearing in the section dealing with moratorium, and they clearly said that "its" mean corporate debtor, and thus the assets of the corporate debtor should not be touched, should not be encumbered, altered, sold, or alienated. However, in this judgment, they've gone a step ahead. Instead of dealing with the interpretation of the word "its," NCLAT has somehow used the reference of section 30 and how is it binding on all the guarantors, etc. And they have taken the flavor that NCLT Chennai in its original judgment has mentioned, that if the guarantee is invoked, then the guarantor, there is a fresh encumbrance on the assets of the debtor, which is in violation of section 14. In my view, that is a bit that view is a bit mistaken, because then in my view, there is no fresh encumbrance that is created. It is only the replacement of the encumbrance from the existing creditors to the guarantor.
This judgment has interpreted a different provision which wasn't considered in the earlier judgments and stipulated that under that particular provision, yes, the personal guarantors would be covered. In fact, going by the logic used by the NCLAT in the judgment, as well as the other rationale given by the Allahabad High Court, such a protection would also extend to corporate guarantors, because the underlying principle is that nothing should be done during the CIRP process that will affect the liabilities and standing of the corporate debtor.
The appellate tribunal ruling doesn't just impact lenders who have now been prohibited from invoking guarantees during the insolvency period. It may also impact third parties who have nothing to do with the defaulting borrower and wish to initiate separate legal proceedings against the guarantor. For instance, let's assume that the properties of a guarantor X are under moratorium, but at the same time, a third party Y, triggered by X's breach of contract, tries to legally invoke a mortgage on X's property. But will Y have to wait out the moratorium?
So there may be some confusion with the way that the judgment is worded. It might lead one to believe that there's a blanket moratorium on the personal guarantor. But if we see the context of the judgment, it merely states that you can't exercise your rights against a personal guarantor if they affect the liability of the corporate debtor. So a personal guarantor may have certain liabilities in its own capacity, a personal guarantor or a corporate guarantor. In such a case, a third party unconnected with the corporate debtor or even tangentially connected with the corporate debtor may proceed against that guarantor, recover its dues, and as long as such recovery does not increase, decrease, or vary the liability of the corporate debtor, there shouldn't be any embargo under this judgment.
Promoter guarantees has always been a very contentious issue, especially under the new insolvency and bankruptcy regime. The NCLAT judgment that we discussed today has only added confusion. But there is a big breather for the promoters in the mix, whose assets were earlier endangered. Now, the reaction of the lawyers on this judgment has been a bit mixed. While some feel that the takeaway from this judgment is that it will lead to better revival process for the insolvent companies, the others fear that promoters will be able to abuse the process now. This is Shivani Saxena for BloombergQuint, Mumbai.
Well, I suspect that the last word on this will have to come from the Supreme Court of India.